Hello and welcome all. Welcome to the webinar organized by IP Metrics Consulting Group. Today's webinar topic is Patentability Requirements for Computer-Related Inventions. Dear attendees, kindly note that all your questions will be addressed at the end of the session. If you can't type the question at the query tab, kindly raise your hand. And now I am pleased to introduce you to the speaker of today's seminar, Mr. Arun K. Narasani, CEO and founder of IP Metrics Consulting Group. Over to you, Arun.
Yes, thank you, Akshata. Hello, everybody. First of all, I'd like to thank you for joining at this late hour on Friday, and for some people, for folks joining from US and Europe, I welcome you all. So today's topic is patentability requirements for computer-related inventions. At best, we can say that the law with respect to patentability of software inventions is vague when it comes to patent law in India. So that makes the topic very relevant, and it's important to have a discussion and debate to help make the prosecution better, especially with respect to software inventions. Only when there is more debate and more discussion, we will be able to give proper feedback to the system so that we can make it more stronger. Before I delve into the topic, I'll just give a brief introduction about myself. I'm the founder of IP Metrics Consulting Group. I've been in this profession for more than 10 years now. Before that, I had been a software engineer with various multinational companies. I've had significant experience in writing and prosecuting applications over these 10 years. I'm a registered patent agent. I'm a registered and certified patent valuation analyst. I'm also a CRIs practitioner, which is kind of a hobby where I love the challenge of solving technical problems with inventors. We do a lot of sessions at technology companies in trying to solve problems and come up with IP. I've had, to my credit, there are a few journal articles in technology and in law. I'm also a co-author on a book on Indian patent law. So without further ado, I will get into the topic. Here's the agenda for the webinar today. We will be briefly looking at evolution of patent law and the relevant definitions as concerned with the software inventions, and then we will review certain provisions in MPPP that help. For people that are not aware, MPPP is the Manual of Patent Practice and Procedure, which talks about how patent applications relating to software inventions must be examined at the patent office. So that gives us a view into how the patent office system views at the patent law. As we stand now, patent law is kind of hazy, and therefore MPPP, or the Patent Practice and Procedure document, gives us a view, internal view of how they might be viewing it. And we will use that as a proxy to see if we can understand patentability of software inventions and the requirements associated with patentability of software inventions better. After reviewing the provisions, we'll get into case law. So we'll look at three. These are not really cases before court, but these were matters decided by the Intellectual Property Appellate Board, and we'll look at what kind of decisions have been made by the IPAB, which is the Intellectual Property Appellate Board, and how that impacts prosecution of software inventions and related patent applications. And once we look at the case laws, that gives us an understanding of where we stand today, and therefore we will try to list subject matters that are allowable and then subject matters that are non-allowable. So for some people who are not used to the legal language, please feel free to write a question. I will try to answer it whenever I get a logical break while I'm talking, or I could do that at the end of the session as well. But then without using the legal language, it's difficult to talk about a legal matter. So I will try to keep it as simple as possible, but at the same time, if you have any question, please feel free to raise that either as part of the question and answer thing, or you can just raise your hand. So once you go into the allowable and non-allowable subject matter and look at the list of things that we could potentially protect relating to software inventions and not protect relating to that, then we will summarize it by looking at some observations that we have seen in our practice as we have interacted over the years with a patent office, and I'll put forward those observations in terms of what we have seen as to how the patent office is receiving, what kind of things they are more favorable towards, and what kind of patent applications they are not favorable towards. And then we will summarize everything with a few points to understand the takeaways from this whole session. All right. So the first topic that we will be talking about, the first section that we will be looking into, is the evolution of patent law. So the first Patent Act after, the post-independence was enacted in 1970. Before that, there had been a few variations of patent law way back in 1852, and then in the late 1890s and 1911, during the British rule of India. Those are all primarily based on the British Patent Act. So that is not of too much relevance because most of it has changed since 1970, and 1970 was the first comprehensive kind of patent act that we ourselves put forward. So that came into force in 1972. 3 amendments were passed after that. So after 1970, nothing was touched unless there was a need to. The need was to get into alignment with the world IP regime because we signed the WTO trade-related intellectual property rights agreement. So because of that, we amended the Patent Act in 1999, which is called the Patents Amendment Act, which provided for allowing product patents in the areas of drugs, pharmaceuticals, agrochemicals, and so on. Till then, we did not have a provision to protect a product or products in these areas of drugs and pharmaceuticals. We could only protect process patents, or we could only obtain process patents. So that was a significant change in 1999, although that's not of too much relevance here, so I'm not going to talk too much about it. The next major revision happened in 2002, which is called the Patents Amendment Act 2002. So that introduced the new patent rules. So there's something called Act, and then there's something called rules. Act is the one that lays down the broad framework for how or what is patentable, what is not patentable, and who is a patent agent, who is not a patent agent, what is a compulsory license, and so on and so forth. It basically defines the framework, and rules are the ones that define how the procedure should be taken forward in, say, protecting a patent or in filing a patent application, and so on and so forth. So, Act is the definition, rules are the procedures. So in 2002, as part of the Amendment Act, a new revamped set of rules were passed, and that was the first time that came out. With relevance to the topic today, one of the major changes that happened as part of Patents Amendment Act 2002 is that the first time they changed the definition of invention after 1970. So that was the first time they changed invention after the Act came into being. So that is, so we will keep a close eye on that in the next few slides. So that after 2002 was the Amendment Act that came in 2005. That introduced majorly, provisions relating to compulsory license as to, okay, what are the governing principles for exporting patented pharmaceutical products to other countries that do not have mechanisms to make pharmaceutical products, which are, probably very essential for sustaining life, something like a cancer drug or something like that. So So there are provisions that was a major provision as part of 2005. However, there was a small change that was made with respect to the definition of inventive step, which is of great relevance for the topic that we're going to talk about. So, what happened was, why is all this relevant, and why are we even talking about these changes? Is that going back to the previous slide, 1970, the Act was only restricted to protecting patents, protecting technology that manifested or that you can see. So technology typically in terms of machinery or products that are physical. So you could not really, the Act was not really addressing, say, protecting processes that ran on computers or any other processes that did not have physical elements involved. So in 1999, when the changes were made to come in line with the world IP regime, we had opened our protection to all kinds of IP, not just, say, for physical machines. And therefore, it was important for India to, change a few things here and there to ensure that not everything is patentable, to ensure the interests of the country are taken care of. So that's why it's important. So we have to pay, attention to these changes to understand where we stand with respect to protection of software inventions today. So with that as background, let's have a look at the definition of invention as it was done as part of the 1970 Act. As I said, it's primarily restricted to manner of manufacture or the manufactured item itself, which is basically a physical product or a machine or a tool or anything that you could touch and feel, anything that runs that you can see. So invention was defined as any new and useful art, process, method, or manner of manufacture, machine, apparatus, or other article, substance produced by manufacturer. So it's either a process of manufacturing a physical object or the physical object itself. So those were what were called inventions, and only those were eligible to get a patent. Right, so that is how it was, and then in 2002, 99 there was change, but then in 99 there were no changes that were of relevance to software inventions, so I'm skipping that. In 2002, the invention definition was changed to expand the scope. As you can see now in 2002, the invention reads as, invention means a new product or process involving an inventive step and capable of industrial application. So this change came in 99, so the same thing sustained in 2002. So now you can see that there is a shift from 1970 Act to here, which is that invention can be any product or any process. Now it doesn't say manner of manufacture or manufacture. It just says that a product or process involving an inventive step capable of industrial application. As long as sorry about that. Yeah, as long as it was a product or process involving an inventive step and capable of industrial application, meaning it had an application in an industry, it is considered an invention. So that is one major change. The other major change with respect to software inventions was the term inventive step was introduced. Till then, the term inventive step was not required because it was not part of the definition of invention. Now, as you see, it is part of the definition. So this was introduced. And the inventive step means a feature that makes the invention not obvious to a person skilled in the art. So this was in line with how the rest of the world viewed inventive step. Typically, if you look at U.S. law or other countries' laws, we have what is called obviousness, or they have what is called obviousness, and so that is typically what we refer to as inventive step in India. So So that was fine, and that took us pretty much in line with what was being followed in the rest of the world. However, now the definition is fine, and what is allowed is fine. We slipped in an exclusion. What is an exclusion? When you define what is an invention, you're saying, okay, these are all the things that fall under this are eligible for patent. Now, in our Patent Act, there are certain list of exclusions, list of subject matter, or list of things that cannot be patented. So then, in determining whether something is patentable or not, you will have to ensure that that is not part of the excluded list. Okay. So one of the important exclusions that was introduced as part of the Patents Amendment Act 2002 was is Section 3K, and Section 3K reads as this: a mathematical or business method or a computer program per se or algorithms. So that means that any invention, even if it's a brilliant new idea or something that's of great relevance to the scientific community or the technology community, if it falls under these, meaning if it is a mathematical method, or if it's a business method, which is a method of conducting business, or a computer program per se meaning computer program as such, which means computer program itself, or algorithms for solving something, as long as if what you invented is one of these, then irrespective of whatever else is there in the Patent Act, those will not be eligible for patent, obtaining patent rights, right? So this exclusion was introduced to limit the patentability of computer-related and certain other inventions. Why? Because India wanted to protect its software industry. Traditionally we've always felt like a patent system benefited multinational companies more. When 1970 Act came, Indian applicants versus foreign applicants, if you took the ratio, it was I think 1:9, and if you took away less important patents out of that, the ratio is even bigger. So we always had this concern in the Indian system that somehow patent system benefited foreign countries and foreign applicants, and therefore we always have a guarded approach towards what is eligible for patent in India, so that we are not constrained in terms of using the technology that is there in the world. So so that is the reason why this was introduced. And so that is one of the, as far as the software inventions are concerned, 2002 Act introduced a lot of major changes. And the next major change, as we discussed, came in 2005. In 2005, there was a slight change made to the definition of inventive step. If you remember, inventive step was defined broadly according to the rest of the world, which is a feature that makes the invention not obvious. However, in 2005, they made it more specific to the Indian situation, and then they said it has to be an invention that involves technical advancement, meaning that it's not just enough that it is not obvious to a regular person in the field, but it should also have significant, or it should also advance the technical field significantly for it to get a patent, or the invention should have a significant economic benefit that it shows. So either one of these, apart from the fact that it should not be obvious to a skilled person in that. So we've added a higher standard or a higher filtering mechanism to provide patent rights for an invention. So you have to have a you have to go through a much tougher screening system, at least according to the letter of law, to get a patent, patent issued in India, according to the law. Right. So with that in mind, we will. So that sets the context for, okay, what is a patent law and what are the definitions with respect to software inventions. So that will help us understand the provisions of MPPP and the case law and so on and so forth. So now we will take a look at the patent practice and procedures and examination guidelines for software inventions or computer-related inventions. Now, why, before I talk about this, it's important for us to understand why it is important to look at MPPP, or the Manual for Patent Practice and Procedure, because the patent law is kind of hazy, because it says that anything is an invention. At the same time, it says that computer program per se is not patentable. Now, where does it leave us? Does it mean that software inventions are patentable or not? So when you say per se, what does it exactly mean? Does it mean that only computer programs are not patentable, or anything that has computer programs are not patentable? So it has kind of put the whole IP system, especially in the IT sector, even into kind of a disarray, and and there's been a lot of debate going on for many years in terms of what is the stand of India with respect to allowing patents for inventions in this field. So that's why it's very important for us to understand whatever cues that we get, and the other cues that we can get from the point of view of the system is the MPPP, which talks about how the patent office should examine applications that come to their office. So that gives us some understanding of, okay, how else the system is viewing, or how the system is interpreting these laws. So that is why we are looking at MPPP. Okay, so patent applications, MPPP has a section where it talks about how an examiner will look at a patent application in this field. It says that with respect to computer programs as a subject matter, examiner first will determine if it's a mathematical method or a business method or an algorithm. If it is any one of these three, he will not look at it anymore. He will say, okay, these three are excluded, and therefore this patent application is rejected. It will not be, the invention is not eligible for obtaining patent rights. So that is the order in which he will look at it, which is fairly clear, which we did not have much doubt about that. Now, another section in MPPP, which is a following section of the previous one, talks about if the claim subject matter in a patent application is only a computer program, it is considered as computer program per se, and hence not patentable. So the important phrase that you need to look at here is the phrase claimed subject matter, which I have underlined as part of the first line. So that has a lot of relevance in terms of technical jargon, so I will not try to go into that too much, but then it's very important for me to explain it. Patents have a section called claims, and claims are basically the heart of a patent application. So claims define what your invention is. So claims try to draw a boundary around what your invention is. So claims are basically sentences that are written in legal terminology to try and be as precise as possible in defining the boundary. So the kind of words that we use in claim to claim a method or a product is important. That's what this examination procedure is talking about. What it says is, you cannot say that your invention is a computer program. Your invention has to be something else, which may have computer program. It's not talking about that. All it is saying is that you cannot say that your invention is a computer program. If you say that your invention is a computer program, it will be outright rejected. So that is all it is saying. So okay, so then that gives us a glimpse of hope that, okay, if our invention has computer program, doesn't mean it is not patentable. If our entire invention is a computer program, then that invention may not be patentable. As long as our entire invention is the software code, is not the software code, we may be able to get patent rights for our invention. Okay, so that's what we can gather from this particular line. I hope that's clear. But if we can, we will discuss about that as we go on. So that gives us some idea of, okay, computer program per se means this. It doesn't mean that no computer program or no invention relating to computer programs are not patentable. It just means that you cannot claim the software source code, or you cannot claim that program that runs on the machine. That is all that means. Okay. So next it goes on and says that claims directed at computer program products are computer programs per se stored in a medium and therefore are not allowable. So what is a computer program product? A disk, a hard disk, a memory device like read-only memory. These are generally termed as computer program products in legal terminology. So any media that has software instructions or the source code are considered computer program itself. I mean, in crude terms, the source code or the object code itself, and therefore those also are considered not patentable according to Indian patent law. Okay, so what we have understood till now is that source code or object code or media or disks or memory devices having source code or object code are not patentable. Okay, so that's what we understood till now. Now, going further, apart from MPPP, MPPP is the general examination procedure for all kinds of inventions. And then in 2013, there were specific examination guidelines that were put forward by the Patent Office for computer-related inventions. So it's important for us to take a look at that. The examination guidelines talk about what is called technical effect. According to this, a technical effect is defined for the purpose of these guidelines as a solution to a technical problem. Okay, so when the invention solves a technical problem, then it is supposed to have technical effect. So why is it important? We will look at it in the next slide. We will understand. But having this definition at our disposal is very important. Okay. In fact, the guidelines also gives some examples of what is considered technical effect and what is not considered technical effect. Higher speed, for example, if the invention achieves a higher speed in doing something, yes, that is considered technical effect. Lesser memory time, more efficient data compression, improved user interface, improved control of a machinery, and things like that. Okay, so anything that is technical and has real tangible, difference in terms of processing speed or usage of memory or transmission strength and things like that, it is considered to have technical effect. Okay, now why is it important for us to talk about technical effect and technical advancement? If you remember, the inventive step definition was changed to include technical advancement. Apart from having a not obvious aspect in the invention, it should also advance the technical field. So that's why it's very important for us to understand, okay, what is technical advancement? Now you introduce a phrase called technical advancement, but in the Act, nowhere is it defined what that technical advancement means. So if I take a software, if I just automate a real-world process, like say a billing system in an accounting firm, for example, and I just write a software to automate the process, is that technical advancement? We don't know unless there are specific guidelines that are provided. So that's why we're trying to understand this. So technical effect is important to understand, is important to have, because the definition for technical advancement uses the language technical effect. That's why we first looked at technical effect before we came here. So technical advancement is defined for the purpose of these guidelines as contribution to the state of the art. It is further, it goes on and says that for software inventions, it is important to make a distinction whether there is a technical outcome or not. Okay, so every invention that has technical advancement will have technical effect. Okay, having technical effect does not guarantee that there is a technical advancement. Okay, for example, if you take an invention to the patent office and say, hey, I have a piece of software that's amazing that uses only like 1/10 of the processing speed, or 1/10 of the memory as compared to what is currently being done. Sure, there is technical effect there. but that doesn't guarantee or that doesn't ensure that there is technical advancement. You haven't really enhanced or advanced the technical field by itself according to the examination guidelines. So the way the Patent Office is interpreting is the standard for technical advancement is way higher than just showing technical effect. So it's not just enough to show higher speed or better usage of memory to get to satisfy the inventive step requirement. So that is what we understand from the definition of technical advancement. Now, examination guidelines also talk about how to determine if a patent application talks about inventions that are not or that are part of the exclusions in the Patent Act. So it talks about a computer program which may work on any general purpose known computer does not meet the requirements of the law. So what it's categorically saying that any software that can run on a generic PC, okay, for the purpose of this discussion, let us understand, or let us kind of come to an understanding that a general purpose computer is basically a normal PC that we buy off the shelf, or a normal computer that we buy off the shelf. So it says any software, irrespective of how much technical effect that software can bring, if it is, let us say it's a device driver that makes it much higher efficient use or much better use of the resources in the computer in, say, providing a display or anything else. As long as it runs on a general purpose computer, it cannot satisfy the requirements of patentability for computer related inventions. So you cannot get patent rights for that, irrespective of what it is. Okay, so now here is the dichotomy. Why is it so intriguing for us to even discuss about all this? Because there are many cases where Patent Office has actually issued patents, and then there are cases on the mobile side, on the mobile devices, for example. They have issued patents which, if you read all this law, you would assume that those are not patentable. But then there are a lot of patents that are issued, especially on the mobile side, even on the general, application side, that you would think that are not patentable according to the law. So that's what puts the whole system in a confusion as to, okay, what is really patentable and what is not, and why is this happening? So one possible reason is that the Patent Office is inconsistent, or the other possible reason is that the law is not written in the manner that it should be written. Okay, so that's why it's very important for us to kind of understand, okay, where as an applicant or as an inventor or as a practitioner, where we need to draw a line to be safe, and okay, what is the minimum bar that we need to cross to say that, okay, we are safe, even accounting for the inconsistencies of the patent system, that, okay, we have accounted for everything, and that we will be able to prosecute an application or take it through a patent office in the manner that we expect. Okay, so that's the thing. So at least according to the law and according to the examination guidelines, any software that runs on any PC without any modifications of the hardware, if you can run that on a PC, that will not be patentable. Okay, so in cases where novelty resides in the device or machine or apparatus, then yes, you can. For example, if you created a hardware box to run a software, for example, something like Apple TV box, or a set-top box that comes with the television cable providers. So you have an Airtel box. So that's a specific box made for Airtel's delivery of its video stream. So that is a specific hardware. It's not a general purpose computer. I mean, it is a computer. It has a processor and all that. I mean, for all you know, you might be buying the processor and everything off the shelf, but then it's not a general purpose computer. As far as given the kind of cases that we deal with Patent Office and what we have seen, our understanding is that a general purpose computer is a regular PC. Anything other than that, any box that you make specifically for a specific application is not a general purpose computer, and therefore any invention or any software, inventive software that you put on that can be patented if you claim it properly. You cannot claim it as a computer program again, but then if you claim it as a box or as a method appropriately, you will be able to get obtain patent rights for that. Okay, so that's so we made some progress from where we started. We started with the Patent Act. We said, okay, there's this inventive step that is defined. We said it has to have technical advancement. At that point of time, we really did not understand what we meant by technical advancement. But then by looking at the examination guidelines and reading through that, now we're able to kind of decipher, okay, where should we draw the line? If you have to draw a line, where should we draw the line? Where should we draw the line? We have to draw the line as long as it doesn't run on a general purpose computer. Then we stand a chance for obtaining patent, provided it meets the other general criteria of obtaining a patent for other inventions, which is the invention, it has to be new, it should not be obvious to a person in that field, and it should be useful in an industry setting. Okay, so that brings us to the conclusion of reviewing of MPPP. I think we've covered a fair bit of ground in terms of understanding, okay, what is now probably patentable and what is probably not patentable, so that we will try to solidify our understanding more by looking at certain case laws or certain matters that were decided by the what is called as Intellectual Property Appellate Board. Intellectual Property Appellate Board is the one that takes appeals. For example, if you file a patent application and the patent office rejects your case, saying that according to the law this is not patentable, or whatever is the reason, if you don't agree with that, then you would go and appeal, and that appeal is basically heard by the Intellectual Property Appeal Board. So there have been significant movement at the Intellectual Property Appeal Board of late. There has been significant movement in terms of matters being heard there, and there have been some important cases that were heard and decided by the IPAB. I'll just use the short form from now with respect to software inventions, which is a good trend, because we need more and more cases to be heard so that law is interpreted and we understand the scope of law and the boundaries of the law much better. So we probably need many more, but this is a good start. So one of the most prominent cases in the software field is Yahoo versus the Controller of Patents. So this probably is a first case of any prominence in this field. So that makes it important for us to understand, okay, where do we stand with respect to the patentability of software inventions. Patent application, in this case, patent application filed by Yahoo related to placing of ads based on bids. So basically it's a method of ranking results based on the bid amount that the providers of that content placed in a bidding engine. So it's like, you and I, we go and do Google advertising, we bid a certain amount for the placement of our search results. So based on that, Google or Yahoo, they basically place our ads higher or lower depending on how much money we paid. So this was the application of Yahoo. In fact, it was not a Yahoo application. It was a company called Overture, which was taken over by Yahoo. So originally the application was filed by this company called Overture. So the case was almost granted. The patent office said, after examination back and forth with the applicant, the patent office said, we are ready to grant it, but there is an opposition being filed by some other company. As long as you go through that, then we will grant the case. The pre-grant opposition, which is called, so before granting patent rights, any opposition can be filed, and such oppositions are referred to as pre-grant oppositions. Okay, so Reed filed a pre-grant opposition on this application. So the patent office basically rejects the patent application because invention does not pass novelty and patentability. We are not really talking about specifics of software related requirements, but based on general novelty and patentability, that case was rejected after the case was opposed by Rediff.com, because Rediff.com said that this thing already exists and it's been done by other companies and so on and so forth. Yahoo did not agree with that, and it appealed, and the case went to it went back and forth between the High Court, and then it came back. The High Court said that IPAB can look at this matter. So finally, IPAB looked at this. Before we discuss what was decided, let's briefly look at the claim. It's a long claim. I had cut it short by more than 50%, but that is how it is. But it's important for us to see what the claim is. So this is how a claim looks like for people that are not kind of aware of what a claim section is. So this is what is called as an independent claim, which is basically the first claim. So it talks about method of operating a computer network search apparatus, basically a computer terminal for generating result list. That has a sequence of steps, storing a plurality of items and receiving a keyword, and then based on receiving keyword, searching a stored set of items, which is basically a database having list of content items, and then ordering the items, and then receiving a request from the user for placing the item at a particular position, charging him the money for that, and then providing information provided with authenticated login access, and so on and so forth. So it basically is a mechanism to conduct the preferred placement of search results, and therefore now the question is this a technical process or is this a business process? Okay, so that was a kind of dilemma in this case before the IPAB. Is it a problem that is is it a solution that is trying to solve a technical problem? If you remember in the technical advancement and technical effect definitions, we read that for it to have technical effect, it should be solving a technical problem, and for it to have technical advancement, it should have technical effect. So technical effect is a minimum requirement, but then doesn't necessarily satisfy the technical advancement. So that's what we read. So now the question is it solving a technical problem or is it solving a business problem, right? So placing search results, or finding search results, or finding the right result for the right keyword is not the problem that is being solved here. The problem that is solved here is one of of business interest, because they're trying to make money, and therefore they're just trying to find which result to place above which one. That's it. So so from that standpoint, the solution is not really towards a technical problem. It is more towards a business problem. Sure, it has technical elements in the sense that you use a technical process to solve it, but the novelty or the difference does not lie in the technical process. It lies in the fact that you are doing business in a slightly different way. Instead of just giving results based on appropriateness of the search query, you are kind of changing the the order of the results based on the significance of business or economic value of in terms of the money that you get relating to that particular result or content, right? So, and therefore it's not really a solution to a technical problem. So that is what was decided by the controller, saying that, see, this invention is only a business strategy. How you place it, it's not really solving anything new, and therefore it does not satisfy the inventive step requirement that we have in the patent law, because there is no technical advancement. For it to have technical advancement, you need to actually solve a technical problem. So that is so that gives us an understanding of, okay, now you know that, yeah, as long just because the process is a technical process doesn't make it a technical invention. So what exactly you're solving there is of extreme importance there. So a lot of business processes today are automated, and everything is done in software. Doesn't mean that everything is solving a technical problem. It's just solving a real-world problem by automating it, right? So if it's an existing process, or if it's an existing phenomena that you're just automating, I mean, you cannot get a patent for that. That's period. So that's a starting point. So if you're just automating an existing process, you cannot get. If you're automating something and then solving a technical problem, yes, then you claim for the portion where you're actually solving a technical problem, and then you get a patent for that. So what is important here is to look at the claim. So the language that is used in claim is very important. So here, if you had talked about a technical problem relating to moving results one before another, for example, if there is a technical problem in terms of using memory efficiently in sorting results, in the process of placing results one above another, then that could be, assuming that it is novel, then that could be considered a technical solution and the associated problem being a technical problem. But since the claim talks about a business process of taking money and then placing the result above, it becomes a business process, and since it's only a business process and you're actually not solving a technical problem, therefore it doesn't qualify for patent rights. Right, so that's one case, which is one of the significant cases. So all these cases basically test Section 3K, which is the exclusion that we talked about, which was introduced in 2002 as part of the Patents Amendment Act. The next case that we're going to talk about is ENRI versus Controller of Patents and Designs. So ENRI is a Japanese institute that came up with a very sophisticated mathematical algorithm to calculate what is called chaos theoretical exponent values. Let's not worry about what that is. It's basically some kind of a factor that needs to be extracted in real time to process speech or voice signals. Before these guys came up with this, there was actually no mechanism to do that in the world. I mean, nobody was able to do that. And therefore these guys had come up with a mathematical approach to solve that, and they automated it and they put it on a computer, and therefore you're now able to do something that nobody else can do. Now, does that count as technical advancement, and therefore is it eligible for patent application? Is something of great interest. So applicant does not. So what happened is he puts forward an application, and then the patent office says, no, we don't think this is patentable because, your invention is basically a mathematical method. So because it's only a mathematical method, you remember in Section 3K we said mathematical methods, business methods, algorithms, and computer programs per se are not patentable, and therefore, because the law is very straightforward with respect to that, we cannot give you a patent, we cannot issue a patent on that. So the applicant did not agree. He said that, hey, this is significant technical advancement. This is not like, I'm just automating something that is existing in the real world. I'm actually, finding something that doesn't exist, and able to do something that, enables to process, voice the way it cannot be done today. So that's he took that argument, and it was appealed, and it went to IPAB. So that is what was the contention in this case. And before we actually look at the results, let's look at how the claim reads. It talks about a system for analyzing speech. A reading means a module to read the voice signal, and then a cutting meaning a module to they cut the signal, slice and dice it in a manner to be able to calculate abstract parameters and calculate the information, and so on and so forth. So it's entirely written not as a machine, but as a set of software modules to calculate some number, right? So even though the claim starts with a system, which generally is understood as a collection of discrete physical elements, like collection of computers or collection of mobile devices and so on. The claim as such doesn't have anything that is a specific machine. For example, you remember we discussed about software that is running on general purpose computer versus software running on a computer that is not general purpose. So there's nothing here that suggests that it runs on a specific machine, and therefore it basically is a method for calculating something, and therefore it was viewed as a mathematical method, and therefore they said the law is very clear with respect to these exclusions, and therefore we think we agree with the patent office, and hence it is not patentable. So nothing more than a mathematical method for solving mathematical claims which are further based on various algorithms. Since this is a mathematical method, Indian patent law does not allow it, and therefore it cannot pass through the 3K bar. Now the thing of relevance here, and why is this case important and why are we talking about it, is that when there is technical advancement, it doesn't guarantee that that thing is patentable again, because you have to look at the law in totality. Just because you have a great invention that has technical advancement doesn't mean that's where the catch is with respect to the exclusion. You read about the invention, you read about inventive step. Now you satisfied both, but then that's the reason why that exclusion exists, which is that not to allow pure software algorithms or software that runs on pure mathematical algorithms are not protected, are not allowed for obtaining patent, right? So now that makes us, as a computer, as a software engineer myself, and I'm sure many of you are, you're asking yourself, oh, does this mean that pretty much every software is algorithm, pretty much every software is a kind of a sequence of steps, or and therefore can be considered an algorithm? Does it mean that no software is or no invention that involves a software is patentable? The question is no, because of other provisions that are there. I mean, we will look at one more case where we talk about that aspect. But if it doesn't satisfy the law, then unfortunately that is how it is. So so mathematical methods are a no-no, algorithms are a no-no, and business methods are a no-no. So even if you morph your patent application, even when it is a business method, for example, let's take the example of Facebook. Facebook is in the business of connecting people, right? You can think of it as an automated way of connecting people, as opposed to in pre-Facebook world, people would be connected by going and meeting and so on. So a lot of automation happens on Facebook, and it could be novel. It could be a new way of doing it, but then probably most of it won't pass through the Indian patent law, and Facebook will not be able to obtain patent rights for a lot of their software because it is a business method, right? Even though it's a novel way of doing it, and even though they may be doing it very in a very novel way, the Indian Patent Office will look at it as a business method, and therefore they will not be able to get patent rights for that. So that is how the Indian law is, and it's much tougher to obtain patent rights for computer-related inventions as compared to other systems. Right. So we'll look at one more case before we move on to the final sections. This case is Enercon versus Alois. Basically, it's a patent application of a German company that was appealed by another company that has a German background. So the patent application relates to power control of wind turbines. Patent is granted to the applicant. However, Enercon files for revocation on grounds of applicability of Section 3K, which means the company Enercon doesn't believe that the patent should have been granted because it thinks that some of the provisions of 3K, which is the exclusions that we talked about, apply for this case. So which means Enercon thinks that it's either is a mathematical method or a business method or an algorithm, and therefore it should not have been given patent in the first place. So after a bit of back and forth, IPAB does hear it again. One of the things that IPAB talks about in this order, in the decisions are basically decisions made by IPAB are called orders. So in this order, one of the things that was talked about is the applicability of the exclusions and how relevant that is to this case. Now, so here's the interesting thing that I don't think the German company makes these hardware. They probably buy the hardware somewhere, and so this is relating to wind turbine, and I'm sure a lot of hardware in wind turbines has become pretty standard because of the way technology has evolved over many years. Now, in this case, this claim is relating to controlling a wind turbine characteristics using a novel approach. Most of it is basically all the invention is in the software that runs on the probably in an embedded format because it's kind of an embedded device. It's not a general purpose computer. So what it does is it just varies some parameters based on wind speed and so on and so forth. So there's nothing new in the hardware itself. However, the hardware is not a general purpose computer. That's the only difference. So the IPAB in this case was, in this case said that the section 3K doesn't apply here because it's not a computer program per se, and it's not an algorithm. In fact, it goes on and says that an algorithm means a set of rules that are defined somewhere as a mathematical formula or something, but in this case it's not a set of rules, and therefore, and also the claim does not talk about any set of rules that are there as part of an algorithm or a mathematical method, and therefore it's not the section 3K exclusions do not apply to this. So this is kind of intriguing. Set of rules, we don't know what is set of rules. Any problem that you're trying to solve is a sequence of steps, and it is called an algorithm. So I really don't understand what they mean by set of rules, but what probably the IPAB is trying to say is, probably the reasoning behind this whole thing is that it's not a general purpose computer. When it's not a general purpose computer, when it's not a mathematical method, a pure mathematical method, because the claim is talking about controlling a wind turbine. It doesn't talk about calculating a number, right? As opposed to in the ENRI case, the claim was directed to calculating a parameter. Here the claim is not relating to calculating something. The claim is about controlling a physical machine. So, and therefore, it's it cannot be considered a mathematical method or an abstract process that runs, or that could be done by human beings otherwise, and therefore it is not considered as part of exclusion. So what kind of claim we write becomes very important. You cannot direct your claim towards something that is that reads like a mathematical method or an algorithm. If it's part of a machine and you control the machine in some way, it actually helps to have a physical machine with moving parts, and therefore it becomes easier. Or that machine should not be a general purpose computer. Even if it doesn't have physical moving parts, that machine should not be a general purpose computer. So it's a combination of many things. One, it should not be part of the exclusions. And then two, it cannot be run on a general purpose computer. So for example, we have seen in our practice that the patent office is lenient when it comes to software inventions on mobile devices. Okay, the same thing if you put it onto a if you invent the same thing in the context of a PC, it will probably be rejected. I'll actually talk about an example like that in the next few slides. So for some reason, even though mobile kind of devices you can buy off the shelf and assemble, just like a general purpose computer today, somehow a mobile device is considered not a general purpose computer, and therefore they're kind of more lenient towards software inventions on mobile devices as compared to software inventions on regular PCs. So the law is kind of a little bit ambiguous and hazy there, but that's how the interpretation is as of today. So that brings us to the end of the case law. Now we'll very briefly look at allowable and non-allowable subject matter, and then quickly wrap it up with observations and summary. So given what we have seen, what is not allowed, our computer programs are not allowed. You cannot say, I claim a program. It will be a no-no, because that is computer program per se. You cannot claim a computer program product. That will be a straight no-no. The moment the examiner sees the claim, he will reject it. You cannot claim a mathematical formula, say a method for calculating something, or method for performing a wavelet transformation. So these are all mathematical concepts, and if your claim is directed towards that, it will probably not go through. If you claim a business method, for example, a method for generating an invoice in an automated manner in a computer network, no, I don't think it will go through, because even though it's computerized, and even though it's automatic, and even though there could be novel elements there, and even though it will have technical advancement and so on and so forth, even if it has all that, because it's a business method, because of Section 3K, it will not be given patent rights. Any automation of real-world processes that run on a general-purpose computer will probably not go through. Okay, so these are things that are not allowed. I mean, as depending based on what we have seen and what we have understood, and based on the experience in our practice. What is allowed? A novel machine or apparatus. An apparatus for delivering video stream to a connected device, wherein said apparatus or said device is controlled by multiple controllers. What am I talking about here? Basically Chromecast. I don't know if you guys have heard of Chromecast. So if you have a specific device like a Chromecast, with which you can use, where you can use your phone as a controller, or you can use your iPad as a controller to control and deliver video content to your TV. So there, that device is a specific device. It's not a general purpose computer. It was a device that was made specifically for that purpose. Now you can claim the device, no problem, you'll get patent rights. Now you can claim the methods, meaning the software methods that run on the device, no problem, you'll get it, because it is tied to a specific machine. It is not a general purpose computer. So things like that. Now one tidbit is that even a mobile device is also considered a kind of a specific machine, at least as of today. So anything that runs, anything that makes a mobile device function in a novel way, in a useful way, in a not obvious way, will also get probably get a patent from the patent office, Indian Patent Office. Okay, so that's the summary of what is probably allowable and what is not allowable at the Indian Patent Office. Now, finally, I kind of conclude with observations. Patent Office has not been favorable to software architecture improvements. We have filed software architecture-based applications for our clients. It did not fly through. Patent Office has not been favorable to methods relying on data structure improvements. For example, if it's in wonderful data structure that makes a search algorithm say 90% fast, it won't go through because it still runs on a normal server, a normal PC, and therefore it is a computer. There is no technical advancement, enough technical advancement there. But Patent Office has been lenient with respect to mobile devices. Why? Because we have seen a patent granted for transliteration in a mobile device. It's if you did transliteration on a normal PC, I'm sure it would not be awarded a patent, but in this case it was. There are scores of examples as to when the Patent Office granted patents for things that would seem not patentable, but then that's the inconsistency with the Indian Patent Office as of today. One takeaway for me there is we have a lot of clients where we file mobile-related technology, and most of it gets granted. So, and therefore, we believe that mobile phones are not considered general purpose computers, even though they could have standard processors and they could have standard memory configurations and everything. They're somehow not considered general purpose computer, which is good for the industry. So in terms of summary, so this is for how I would summarize. Software-based inventions that run on traditional computing environments are unlikely to pass through, and inventions that are kind of embedded, including mobile devices, are more likely to pass through, provided they do not directly fall onto the exclusions. And a claim has to be directed in a right manner. I mean, you cannot just claim a mathematical method or calculating a value, or you cannot claim an algorithm. It has to be claimed towards, in a manner probably towards a machine. Even if it's a method, it should be like, controlling a machine to perform in a different way, or, for example, making the touch screen better, for example, or making a touch sensor better. Or so it basically is controlling the physical aspects of the device. So as long as claims are directed towards such aspects, I think they will pass through, even though the invention primarily lies in the software. Okay. And a method enabled by software can be claimed, provided it does not follow the quote-unquote set of rules that are mathematical and business process oriented. So that would be the kind of summary of where we are in terms of Indian patent law with respect to software inventions. So the question whether software inventions are patentable, absolutely yes, but they have to be directed in the right manner, written in the right manner, and we do that day in and day out. So we understand the nuances, but it's not very simple for people that are not used to it to understand. So yes, they are patentable, but then there are a lot more restrictions as compared to, say, US or European system. With that, I will leave the floor open for any questions. I'll be happy to answer any questions that you guys may have.
Thank you, Arun. The first question that I would like to put forward is, does software inventions be industrially applied to be patentable?
Yes, absolutely. Software inventions have to be industry applied. So I did not go into the very basic requirements of patentability because this session was primarily intended for addressing the issues specifically with respect to CRIs. The basic requirements are novelty. It has to be, the software invention has to be new. It has to be non-obvious, which means it should not be obvious to a common person, and then it should be industrially applicable. So all these three have to be satisfied, and all the other requirements that we discuss with respect to exclusions and with respect to technical effect and technical advancement are all requirements on top of the basic requirements. Yes, so software inventions also have to be industrially applicable. If it does not have a utility in the industrial setting, then it would not be eligible for patent rights.
Okay. Now the second question is, could Yahoo and EMRI have written the claims in manner similar to Alois Woben to get patent?
Yes and no. So Yahoo, it depends on what they wanted to protect, right? I mean, the question is, what do you want other people not to do? So many times this consideration comes into the picture. Why are you filing a patent? You're filing a patent because you don't want others to do something. In this case, it happens to be a business process. What happens is when you try to change the claim to suit the patent law requirements, usually you tend to change the invention itself, and it does not serve the purpose of stopping others from using something which is what you want to protect. And therefore, it becomes a tricky situation. In this case, I think it would have been very difficult for Yahoo to do it. However, I think it would have been slightly easier for ENRI because they had a very novel method. They could have directed it to a specific hardware configuration or a specific machine doing speech processing. ENRI could have definitely done it. For me, I don't think Yahoo could have done it because they're bang on trying to protect a business method, which would have been difficult to come through. In the case of ENRI, there was technical advancement and there was technical effect, and therefore I think they could have done it.
Okay. Now the third question is, so if you use a mobile patent in another, like that is different mobile device, will it be okay?
Yes, yes. I mean, if it usually in India, if it has to get a patent granted, typically the claims have to have machine elements tied to it, and obviously it would have some kind of configuration that is tied to that machine. As long as you use a new machine and new modules, yes, it probably you can get away from that particular claim, and therefore you will not infringe on that claim. So you will be able to use it. So it really depends on how well the claim was crafted. But if I have to give a very simple and short answer, yes, you will probably be able to work around the claim and take care of business.
Okay. Now, again, the next question is related to the claims thing. Again, in case of ENRI, if they had tied it with a device, could the process be used as a used on a PC?
No. That process cannot be a regular PC. So that's the thing. So, for example, if ENRI said that they applied this machine in a box, for example, company like DTS, which do speech encoding, for example, they come up with boxes for specific purpose processing of signals, audio signals, and so on. If these guys had applied this in such a context and they had claimed in such a context, they would have gotten that claim awarded. If they wrote it in a manner where they wrote as if it runs on a general purpose PC, it could still go through, but then it should have to control probably another device in the network, not the same computer. You cannot say that the computer is processing signals. If it says that, okay, it is controlling another device in the network, then yes, there could be a possibility there. So there are certain nuances here. I'm going into a little bit more complexity. I kept it very simple in the session, but if you can write it in a way, and it is definitely possible that this software is controlling some other device on the network, it is possible to gain patent protection. But if you just write it simple in a simple manner, as if it's as a whole it's running on the same PC and all the effect is on that PC, then I think the chances are very minimal.
Okay. Now the next question is almost related to the same thing. So if such, what would be the use of such patents then?
The use of such patents, that's in India, the use is very limited in the sense that you are protecting yourself. You are protecting yourself from potential infringement claims from other people. So if you have a patent, then you're sure that first of all, nobody can use the specific product or the method that you're using in the market. And that nobody will obtain patent rights and come after you. Okay, that's a basic minimum expectation of getting a patent. At least protect yourself. So with respect to India, what they're trying to do is they're making it very difficult to write generic or broad patents, and therefore making it easier for Indian software system to kind of flourish without worrying about other people's patents. That's the whole purpose of this kind of a patenting system, which is that it gives you a basic protection for what you're doing, but then it doesn't give you that leverage to go after many people. Like in the US, you could write very broad patent and then you can go after everybody, and then people have to be worried about, okay, whether I'll be sued for this or not. So Indian system kind of protects the Indian software industry in that manner. So that is how I view it. As a startup or as an inventor, you should still be looking at filing a patent. Just because you cannot assert your rights in a broader sense doesn't mean that patents are useless. Patents are useful in terms of protecting your rights and ensuring that you will not fall into an infringement scenario later on. So that from that perspective, patents are useful.
Okay. Now the next question is, are mobile and tablet apps patentable? For instance, can Facebook get a patent for automating social connectivity through mobile devices?
Yes, as of now, the way the patent office is treating, as long as the claim is not directly talking about the business method of connecting people, if the app solves some technical problem, the question here is whether the claim is directed towards a method that is solving a technical problem. If it does solve a technical problem, yes, it would be, even if it is an app on a mobile device, yes, it would be eligible for a patent. Again, the trick here is we're talking about Facebook and what kind of processes is it enabling it through the app. If it's a business process, then it will probably not fly through. For example, in the Yahoo's case, even if it were a mobile application, I don't think it would pass through because the claim was directed towards a business process or a business method. I think the same thing would apply for Facebook. It depends on what kind of claim they write. If the method of the system that they're claiming is towards solving a technical problem, then absolutely yes.
Okay. I think that's it. We don't have any more questions raising in here. I would like to thank you all once again for attending today's webinar. For more details, queries or suggestions, please write to us at contact@ipmetrics.com.
I believe there is a raised hand
That's from
Sunil.
Sunil Gupta.
Has he already asked this
Yeah,
question?
he has asked a question that is related
Okay,
to
good.
some mobile app.
All right. Yeah, thanks.
Okay. And for more details about the company, you can visit www.ipmetrics.com. And thank you. Thank you, Arun.
Yeah, I would like to request all of you guys to follow us on LinkedIn for more updates and following sessions. We plan to conduct regular webinars every month. So I request you guys to follow us on LinkedIn. That's where most of our activity gets pumped into. And also, if you like the content, please join us at our blog, which is at blog.ipmetrics.com. All right. Thanks a lot for joining the session. Really enjoyed talking about it. I hope you guys enjoyed it and learned something from this session. Thanks a lot. You guys have a good evening and good day.
Thank you. Thank you all.